In this session, we're going to continue our examination of the major categories of intellectual property. So we've talked already about patents. In this session, we're going to begin with copyrights. So copyright, this is defined as the legal right to prevent others from copying an original expression embodied in an original work of authorship fixed in a tangible medium. So often when you hear copyright, you probably think of books. If you open up a book and turn to the first few pages of it, you're going to see that little C with a circle around it, indicating that this was copyrighted, and it's going to tell you the date that it was copyrighted. This book was copyrighted in 1979. That's what we're talking about when we're talking about copyright. And that gives you the legal right to prevent others from copying your book. That's the original expression that's embodied in your work of authorship. And the tangible medium there is a book. So you're getting the legal right to prevent others from copying it, from using it, from reproducing it, from distributing it, to publicly displaying it or performing it. And you also get the right to create derivative works of your copyrighted material. So if you've written a book, then you have the ability to derive new books, subsequent books from that original book. So let's take the Harry Potter books. You write that first Harry Potter book, it's copyrighted. Then you have the ability and the exclusive right to create additional books using that same set of characters and the same, city and circumstances of what's going on. It would have been copyright infringement for someone to have come out and said, I like the Harry Potter books. I like these characters. I like this setting. I'm going to write a new book. And then to write another book that uses the same characters, the same setting, all of those things, that would be copyright infringement. And so this is what protects you from your original expression, as well as gives you the exclusive right to create any derivative works. So to be eligible for copyright protection, the material must be original and it must fall into one of these categories here. And so obviously if it's original, that means it's something new, it's something unique to you. It's not something that you're copying from somebody else or taking from someone else. It's your original work. And then it's got to fall within one of these categories. And so you've got literary works, musical works, dramatic works, pantomimes or choreographic works, pictorial, graphic, sculptural works, motion pictures or audiovisual works, sound recordings or architectural works. So if you go back and think about what we've talked about with utility and design patents, that much more falls in line with what businesses and companies are doing when they're creating and developing new products or perfecting products. Copyright comes much more back to the arts, in terms of music and literature, um, stage productions, movies, things like that, music. All of this is falling within um, more of what copyright is designed to protect. So you don't write a song and apply for a utility patent for it, because that's not the law that's meant to protect that. That would be protected by copyright. So to be copyright protected, the work has to be captured in some tangible medium that can be reproduced or communicated. So if you just, let's take music, if you're just sitting there at a guitar and you're sitting on a bench and you just start strumming and you sing some song and that's it, you just make it up on the spot and you move on, that's not something that's been captured in a tangible medium form. Rather, it's got to be captured in the terms of you've written down your guitar chords and your words of the verse and the chorus. If you don't write down those lyrics and the music, then there's no medium that's been captured in. Or if it's been not been recorded, if you recorded it, then it's captured. If you've written it down, then it's captured. It's something that can be reproduced or communicated. But if you just did it and walked off and the only form of it being captured is in your memory, that's not sufficient. So the example too is a literary work. If you've written something, you've captured it on that manuscript, or you've got it saved as a digital copy on your computer. And it's important to point out that copyright does not include material that's such as like common phrases or names or readily known information or facts. That's not something that's original. All of those things are something that is already in existence, that's well known. There has to be originality to the work. So let's take the example of facts. Facts aren't copyrightable. I can't copyright facts about history, but I could copyright something that if I write a history book where I take a bunch of facts and I compile it together to write a book. That's something that could be copyrighted. So if the requirements are met for a copyright, then the work is automatically copyrighted, and it provides the author or the creator with the exclusive economic rights to reproduce it, to create derivative works, to share it, copyrighted material with the public, to perform it in the public, to display it in the public, or to play it if it's an audio recording, to play it. And so if you remember back when we talked about patents, the utility design patents, whatever class you had to fill out that application. You did that provisional application, you did the non-provisional application, you went through the process and got a patent granted. And you had to go through that whole process in order to get those protected rights. Copyright is not that way. Copyright, if it's original and it's captured in some form, and it falls within those categories, then you're gonna automatically have copyright protection. So in that instance, you don't have to apply with the government to get copyright protection. You don't have to wait for something to happen. So in um, I had a professor in law school who told us this, and I don't know if it's still the way or not, but I think the laws have changed to encourage you, as we'll see in a few slides, to go ahead and register your copyright. But you're not required to register your copyright, and you get copyright protection automatically. Well, my professor in law school worked in the music industry um, back in the 70s and 80s, and he said that it was very common for songwriters to what they would do is they would, when they wrote a song, the lyrics and the music, they would make a copy of it and they would fold it up, they put it in an envelope, and they'd mail it to themselves. Because by mailing it to themselves, it gave them an established postmarked date, and they would leave the envelope sealed. To where if there was ever any sort of dispute about the originality or the copyright of their song, then they could go back and have proof that, look, I wrote this and I had to have written because it's sealed and it's postmarked and it's unopened as of this date. And so it gave them the proof to help prove and establish their copyrighted material. And so copyright is unique in that if I sit down today and I write a work of art, it's original and I complete it and it's captured in a form, then I arguably have copyrighted my story. Or if I write a song on the guitar, I've arguably copyrighted that material. In a patent scenario, you got to apply and go through the application process and the waiting process for that to happen. So when we say copyright, you just automatically think that whoever wrote the work or whoever uh, wrote the song are the ones who is the author or the owner of the copyright. But that's not necessarily true. The author of the copyright is either the person who did create it, who wrote the story or who wrote the music, or it's the party for whom the work is prepared. So if you have an instance where it's work made for hire, then the owner of it is the entity that's hired you, not you as the writer. So work made for hire occurs when it's an employee that creates work in the scope of their employment. So we used to live in Nashville. Nashville's close by, and we had a friend that lived in our neighborhood when I was growing up that was a songwriter, and he worked for one of the big music publishing companies, and he was on staff. And the songs that he wrote, he was in a work made for hire situation in which the songs that he wrote, he may have written them, but he wrote them in the course and scope of his employment. And therefore, those songs were actually the music, his employer, the publishing companies, they were the ones that had the copyright on that music. You can also have work made for hire when the work is specially commissioned. And so you will have a signed writing that states that this is a work made for hire. So it's going to establish that although I'm the person that's writing this music or this story or whatever it may be, we have an agreement that I'm doing it, but I'm doing it for, I'm being commissioned, paid to do this story, to do this music for someone else. And that someone else or that entity or company is who will be the owner, the author of that copyright. So copyright has a limited lifespan. Talked about patents, they have limited lifespans. Utility was 20 years, design was 14 years. So copyright, they also have a limited lifespan, but it's much longer than a patent. So copyright, if it's an author, so if the author is an individual, if it's a real person, then it's the author's lifespan plus 70 years. So someone who writes music, let's say John Mayer, he writes a song, the copyright on the song is his lifetime. So if he lives another 50 years, it's going to be 50 more years plus 70 years. So after John Mayer dies, the copyright's going to exist for him or his estate, whoever gets it, for 70 years beyond. So, like we talked about, you could have a work made for hire situation where it's not necessarily an individual who owns it, even though I wrote it, the owner would be someone else. So the example of my neighbor in Nashville who wrote music for the publishing company, in that scenario, the publishing company is the one who owns the copyright. So in that scenario, the lifespan of the copyright is the shorter of either 95 years from the date of first publication or 120 years from its creation. So it's possible that you could have something that's written but it's not published for 40 years. In that scenario, it would be 120 years from creation because that's going to be the shorter of 95 years from publication. So, like we talked about a few moments ago, copyright is automatic. So when you've met the elements of it, you have something that's copyrighted and protected. You don't have to wait for the government to review it and to um, grant you a copyright. But the author is encouraged to register their copyright with the governmental office known as the Copyright Office. So the reasons that you would want to register it is that um, in order to be able to sue for copyright infringement, that copyright has to be registered. So you're incentivized to register for it because you're going to have to do it if you're going to ever sue anybody for copyright infringement. And really, without the ability to sue for copyright infringement, you kind of lose the protections of a copyright. So registration is also incentivized because if you have registered it, then you can get additional damages. You could get, for example, attorney's fees for having to seek this. So you can get additional damages in a copyright infringement case. And registration also creates a presumption of ownership and validity of the copyright. So in if there's a dispute in copyright infringement, then it's presumed that since you registered the copyright that you're the owner of it, and it's also presumed that your copyright is valid. And so for these reasons, although it's not required, you're usually encouraged to be able to go ahead and register your copyright with the Copyright Office. So let's talk briefly about the last two categories. So trademarks, these are the protection of works or symbols that identify the source of the goods or the services. So this is most often what you think of when you see a symbol of a company or of a brand. And so when you what you're trademarking is really the symbol or the emblem of a company or a brand. So it will indicate, a trademark will indicate who created or is responsible for a product. May also imply the quality or the condition of goods. So if you see Ford Motor Company symbol, that indicates who created it, and it's a Ford car, and it also may imply the quality and condition of the product because you may have a known expectation of what Ford's product is. You may think that they make good, reliable trucks, and so that may imply to you seeing that emblem, that trademark, that this is something that you could believe to have good reliability. Trademarks, unlike the ones we've talked about so far with copyright and patents, trademarks are indefinite, and that is because of the association that trademarks have with goodwill. Trademarks are associated with the company or the business, the brand. And so because of that, comes with an element of goodwill. And so it would not be fair to have a trademark copyrighted for Ford and Ford have to lose its trademark eventually and someone else be able to use it. It would lose its goodwill for the company and it may really turn into a case of misrepresentation because people may start seeing the emblem and think this is a Ford when really it's some other company or some other brand. So trademarks have an indefinite lifespan. The other last topic that you have that makes up intellectual property is trade secrets. Trade secrets are confidential information that provides a business with an advantage over a competitor who don't know the information. Trade secrets, like trademarks, are indefinite because if it's something that helps you that's secret of the company, then it will remain a secret. It'll have indefinite protection as long as you don't disclose it. If you disclose something as a trade secret, then you can't expect to be able to go back and keep it a secret if you've already made it public. And then on top of that, it has to be sure that it's not someone else's secret. So if you've misappropriated something from somebody, you can't have something that's a trade secret if it really came from another company. So trade secrets, this is long and vast, so it could be things such as information about how a process is done. It could be things like a vendor list, a pricing formula, all sorts of things that could be beneficial to a business over their competitors. So here is the most common definition that's given of trade secrets, and it's a good one. It's from the Restatement First of Torts. And so a trade secret can consist of any formula, pattern, device, or compilation of information that's used in one's business and which gives them an opportunity to obtain an advantage over competitors who do not know it or use it. It can be a formula for a chemical compound, a process of manufacturing, treating, or preserving materials, a pattern for a machine or other device, or a list of customers. So the book gives a very good example of Coca-Cola. What is their primary trade secret? Obviously, it's whatever the recipe is for Coke. That's something that is a trade secret. It's something that is protected, that needs to be protected, and it allows them to have a competitive advantage over everybody else because somebody else can't make Coke.